We're just having some technical difficulties. We'll be on shortly, guys.
Okay, thank you.
Thank you, Faith. Good morning, Your Honor.
Morning. Sorry about that. All right. So the matters I'm calling are the joint cases D101CR 2023-39, D101CR 2023-40, and D101CR 2023-41. David Halls has been excused by the court. Since this does not concern him, he's entering a plea. So I don't know if parties state their name. We can start with Heather LeBlanc or Alec Baldwin.
Yes, Your Honor. Good morning. Heather LeBlanc on behalf of Alec Baldwin.
All right. Thank you. Go ahead, Mr. Bowles.
Your Honor, good morning. Jason Bowles for Hannah Gutierrez-Reed. And Todd Bullion also is on.
Okay. Thank you. And Ms. Carmack-Altweiss.
Yes, Your Honor. Mary Carmack-Altweiss for the state.
All right. So let's begin with Ms. Carmack-Altweiss. What we're here for is to determine whether you can appropriately include the actively participate in this with the special prosecutor as co-counsel. Go ahead.
Yes, Your Honor. This is in response, Your Honor, to the letter to all counsels in this case that you sent to us, I believe, on March 30th. The first question posed to the state by the court was whether I have good cause to appoint a special prosecutor. To be clear, this was not an appointment of a special prosecutor for a conflict or an ethical reason. Instead, it was for other good cause reasons as laid out in 36-1-23.1. And those are laid out in our brief, but to be brief, quite frankly, we need extra manpower on this case so that it does not take away from prosecuting all of the other cases currently in our office. It would be unfair to the citizens and constituents in Santa Fe and the rest of the First Judicial District if we diverted resources from prosecuting any of those cases, or maybe even not even being able to prosecute those cases because our time, attention, and resources are directed at this case. This was the reasoning behind our seeking the emergency grant of money from the Board of Finance and the reason for the request for the special appropriation from the legislature, which was granted. Both of whom, executive and legislative branches, accepted that reasoning and allocated funds specifically for extra attorneys, staff, and experts. Additionally, the Board of Finance granted half of the requested money as an emergency based on its statutory authority. However, Your Honor, all of the money in the world doesn't help prosecute a case if we cannot find the bodies to fulfill the roles in our office to prosecute both this case and every other case in our district. This is a statewide problem. It's not unique to the First Judicial District. I, however, am the last DA to actually be getting hit with this problem. Until approximately, I guess, early March of this year, we were, if not fully staffed, we only had a couple of vacancies. However, by the end of April, just prior to the scheduled start of this preliminary hearing, I will have a 1/3 vacancy rate and be down 9 attorneys in an office of 24. The 5 most recent departures of attorneys are not just leaving our office, they are leaving the state. That means that every attorney in my office, including me, will be carrying a heavy caseload. Right now, before this even happens, all of my senior attorneys are carrying a minimum of 5 first-degree homicide cases. I only have 3 others right now because I've been limiting my intake in order to help carry the burden of this case. And while it is only a 4th-degree felony, it has and will continue to be heavily litigated and require massive amounts of time, massive amounts of attention, and massive amounts of resources. All of this is to say, Your Honor, that we clearly have good cause under the statutory authority and under State versus Hollenbeck to appoint a special prosecutor. I'm going to quote from Hollenbeck. This is paragraph 14. The reasons that the district attorney cannot prosecute a case need not be legal or ethical. It could be a matter of a lack of resources. And then further up in that paragraph speaks directly to my point. If the district attorney lacks sufficient assistance to timely and competently prosecute all criminal cases referred to their office, meaning, Your Honor, that if we don't have either the budgetary we have budgetary constraints and or assistant constraints, that is good cause to appoint a special prosecutor. Now, on to the second question, is whether after that appointment of a special prosecutor, I or my office can continue to co-counsel. I'm going to stay with Hollenbach, where in that same paragraph, 14, it states that the rationalization for requiring authorization for prosecution is to avoid prosecution by persons who are not held accountable or subject to the oath of office. That statement, I think, clearly shows that district attorneys are to be held accountable for the decisions and prosecutions they make in the office, when, as here, the decision is not based upon a conflict or an ethical reason. This dicta, I think, also implies that we're held accountable and thus should be allowed to be a part of the prosecution if we are not conflicted off of the case. And indeed, that's exactly what I'm trying to do here. I'm getting the extra resources that we need to successfully prosecute this and all other cases in our district, while also participating in the prosecution such that I, as an elected official, am held accountable. I'm trying to ensure my public accountability in this case, not avoid it. Co-counseling meets the twin goals of public accountability and appropriate resource allocation. State versus Surratt stands for the proposition that a special prosecutor steps into the shoes of the elected DA and can make all decisions, including delegation, in that prosecution. In that case, however, the appointment of the special prosecutor was because of a conflict, not good cause. This case is entirely distinguishable, as there is nothing in Surratt that would preclude a DA or an assistant DA from assisting the special prosecutor if there was no conflict. Further, Your Honor, although there is not any case law specifically on point, I would point out that there have been many instances of co-prosecution between agencies. The Attorney General's office often loans its attorneys to district attorneys' offices around the state to co-prosecute cases, again, based on lack of resources. Just in a quick search over the weekend, I found one from the 2nd Judicial District, State versus Stephen J. Goldman Jr. It was prosecuted by the 2nd Judicial District Attorney, but there was an appointment and oath of special prosecutor under the exact same statute that I have appointed or am attempting to appoint a special prosecutor here. And that was a deputy attorney general that assisted and co-prosecuted with the deputy DA down in the 2nd. We have also here in the 1st, we have co-prosecuted with the superintendent of insurance. And while it is relatively rare, it does happen. And there's nothing in statute or case law that prohibits it. Finally, were you to disallow my office from co-prosecuting, it would prejudice the state's prosecution. We are now roughly 5 weeks out from the scheduled preliminary hearing. We have had to, in the last couple of weeks, we've had to find, contract with, and appoint a new special prosecutor. And for that person to get up to speed and entirely take over the prosecution without the benefit of our 18 months of work on this case, our infrastructure and institutional knowledge, it would not only prejudice this case, but completely hamstring the state or the special prosecutor's ability to move steadfastly towards the preliminary hearing currently set on May 3rd. So for these reasons, Your Honor, we're going to ask that you enter a finding of good cause to appoint the special prosecutor in this case and allow the co-prosecution to move forward as a recognition of the DA's discretion and so as not to prejudice this case against the state.
Just a minute, Mr. Bowles. What was that case you found over the weekend that you didn't provide until now?
Oh, it's just an example. It's I can give you the case number. It's D-202.
Wait a second. I'm in Westlaw, not in Odyssey.
Oh, sorry.
Wait a second. All right, what is it?
D-202-CR-2019 2023-03363. And it's State versus Stephen J. Goldman Jr. It was an appointment that happened in January of this year, and it went to trial in early March.
All right, just a minute. D 202 CR 2019 what?
03363.
What was the entry of that date? What was the entry?
Well, the appointment and oath of the special prosecutor was entered on January 31st, 2023. And
Right.
it was co-prosecuted between the second and the Attorney General's office in March at trial.
All right, thank you.
Thank you.
Mr. Bowles?
Yes, Your Honor. Good morning. Judge, I want to first start with the court's question and the language of the statute. And I think it's a pretty straightforward answer when we start with the language of the statute, which is, as this court pointed out, 36-123.1. In that statute, which is the special counsel appointment statute, it says, and the district attorney just quoted, when a district attorney cannot prosecute, that's the key language. When a district attorney cannot prosecute for either ethical or good cause, then they may invoke the special counsel appointment process. Now, the district attorney in their brief ignore that word cannot. And the statute does not say, it does not go on to say when a district attorney cannot prosecute the case without assistance or without a co-counsel. It flat says when a district attorney cannot prosecute the case. That really, the plain language is the beginning and end of the inquiry, respectfully, because what the district attorney has communicated here is that they can prosecute this case. They are prosecuting this case, and they have participated substantially in it. They are just asking for, admittedly, more resources, state taxpayer funding, and an additional augmentation of their staff to prosecute this one case. Now, this court also cited us to Hollenbeck and Surratt. In both Hollenbeck and Surratt, we dealt with, first of all, Surratt dealt with a situation of a conflict, and that is correct. In that case, the district attorney had a special appointment to the 12th Judicial District, another district attorney. On remand, that district attorney could not prosecute the case, so she delegated the case to the 9th Judicial District Attorney, who then prosecuted. There, the court said all of those appointments were proper. The court also said that once the special prosecutor was appointed, that person took over and stood in the shoes of the district attorney and thus was imbued with the power to appoint a new special prosecutor. So that was upheld. The court cited multiple cases from out of district, emphasizing that the special prosecutor takes over and steps in the shoes of the district attorney. So that case supports the idea of the plain language in that if the district attorney truly cannot prosecute a case, if they are facing a crisis, if they're down 1/3 of the staff, as the district attorney has said, then they can invoke that statute and appoint a prosecutor to take over the case. Hollenbeck, a case this court cited to us, was a case in which the district attorney tried to appoint a special prosecutor without going through the statute. They admitted on appeal they didn't have good cause or conflict reason to do so, and indicated essentially in their inherent authority they could appoint somebody. The court said no, that was not correct. The statute applicable is 23.1, and that statute requires that the district attorney state either a conflict reason or that they have good cause to appoint somebody else. Here, we're not dealing with the conflict reason. Here, we are also not dealing with the attorney general. Ms. Carmack Altwise just cited this court to a example, which I haven't seen either. I don't know what happened in that second judicial case. I haven't looked at the docket. I'm not sure what that case talks about. However, that involved the attorney general. That involved another person that takes the oath of office that's subject to the voters. If the voters don't like him, as the court said in Surratt, they can vote them out on the decisions they make to prosecute certain people and use certain resources. Here we're dealing with the district attorney wanting to appoint a private person to a special prosecutor using taxpayer funds, initially requesting over $600,000 and now requesting over $300,000. Some of the reasons given have been that this is a high-profile case, that Mr. Baldwin has a plethora of resources and high-profile attorney and this and that. The other thing I wanted to point out that's not only inconsistent with the statute, fundamentally unfair, we're representing Hannah Gutierrez-Reed. She is a 25-year-old female who does not have all of those resources and does not have a war chest to fund 9 experts like the state has. And the state's essentially saying we get to put all this money together, a special taxpayer appropriation to go after not only Mr. Baldwin, but also Hannah Gutierrez-Reed. That's not what the statute was designed to do. It's not designed to allow a district attorney to augment her office and staff in one particular case they pick. They cite this court and they use multiple fiscal years, but 7,200 cases they've had and 30 homicides they've resolved in a couple of years. And I'm not doubting they're incredibly busy and incredibly overworked. I'm not doubting that. We all are. But what I'm saying is, why this case does the district attorney get to invoke that at a co-counsel and use taxpayer money to fund that case? And the long and short of it is, the simple answer is, the statute does not provide for it. The statute says when a district attorney cannot prosecute a case. And none of those cases, Your Honor, Surratt, Hollenbeck, and Cherry Homes, which the DA cited, in none of them did the district attorney continue in the case. Once they made the appointment, the special prosecutors were the ones that always took over. And for those reasons, Your Honor, on the fact that the district attorney hasn't stated good cause to date to not prosecute it, I don't think they've even made the threshold showing to tell the court either we can prosecute this or we cannot. It's an either or. They haven't done. They haven't met that element as well. And for that reasons, Your Honor, we'd ask this court to hold that under the statute, the DA has to either say they can prosecute or they cannot. And then the statute's invoked.
May I respond, Your Honor?
Yes, thank you, Mr. Bowles.
Your Honor, first of all, to Mr. Bull's point about the Attorney General's 36-1-23.1 does not make any sort of distinguishing between an Attorney General, someone from the Superintendent of Insurance, and a private counsel. In fact, it says the DA, and then I'm going to skip ahead, may appoint a practicing member of the bar of this state to act as a special assistant district attorney. That's what happened in the case that I pointed you to from the second. Ms. Staley, the special prosecutor appointed in that co-prosecuted with the second judicial district attorney. While she is an attorney general, that is not mentioned in this, and it really had nothing to do with it. She was a special prosecutor. There is no distinguishing between AGs and private counsel in the special prosecutor statute. The other thing I would point out is we did not make a request for extra funding for the State Board of Finance because it was Alec Baldwin. We made that request because there were potentially 3 to 5 people that we were going to be charging, meaning 3 to 5 trials, 3 to 5 times where we would have to bring in experts, use our resources, and pay out for that. The vast majority of that money is for experts. Additionally, the Board of Finance did question me at the time. Has any other district ever come forward and asked for money for one specific case? I had done the research and the answer was yes. The library shooting in Clovis, New Mexico, that was only one co-defendant, and they went to the Board of Finance and they got extra money to prosecute that case. This is not unprecedented in the state. It has happened before. The Board of Finance considered that and they found cause to give me emergency funding for that. And so if there was good cause for the emergency funding, I think that we have absolutely met the threshold for good cause to appoint a special prosecutor. To be perfectly honest, things have changed in this office since I first asked for that emergency funding. We are down, right now we're down 7 attorneys. We'll be down 9 by the end of this month. And so I have had to take on an increasing load. And I am trying to continue to prosecute this case with the special prosecutor because I think it's important that this office be involved in that case. I think for the public policy and public accountability. And quite frankly, the reality of prosecution in the state of New Mexico is that DAs around the state are entering into contracts and agreements with private attorneys, with other state agencies in order to effectively prosecute because we are all down so many attorneys. And this hybrid prosecuting situation is one of the only options we have other than to just start turning cases away. That doesn't really apply to this case, but we are in dire straits. I think all DAs around the state would agree with that. And in fact, I think the Attorney General would agree with that as well. They're hosting job fairs left and right because there are not enough prosecutors in this state. And so we have to be able to look outside of our offices in order to find people. So that is our good cause, that we do not have the sufficient manpower to fully prosecute this by ourselves. Bringing on a special prosecutor helps with that by taking some of the burden of prosecution. And that's really all I have to say, Your Honor. Thank you.
All right, let me just address your last minute identification of a case that provided a attorney general with a special prosecutor appointment. That doesn't resolve this issue whatsoever. I can point to the James Boyd case, and I can tell you that when that case was given to Randy McGinn, the Second Judicial District did not involve itself whatsoever in that case. When I'm looking at the pleadings, I'm looking at her budget, I'm looking at her billing. So there you go. So I'm not really going to give that credibility. I don't know what other judges are doing and why they're doing it. What we're here today for is, simply put, as Mr. Bowles put it, the statute 36-1-23.1. And I have to right up front tell you, I don't read the statute as you read it, Ms. Carmack-Alvoice. I think that it's a twist to read it the way you read it. It says each district attorney may, comma, when he cannot prosecute a case for ethical reasons or other good cause, comma, appoint a practicing member of the bar, et cetera, et cetera. To have it read the way you do, you would have to ignore a lot of language. And it would read each district attorney may or other good cause. That's just not a grammatically correct sentence. I really think case law supports the conclusion that, and I'll quote from Hollenbeck and Sarah, that you read it together, as Mr. Bowles is saying. Each district attorney may, when he cannot prosecute a case for ethical reasons or other good cause. That is the way to read that statute. You're ignoring the cannot prosecute emphasis on good cause. When you look at Hollenbeck, paragraph 7, it says it recognizes two lines of statutory authority. It says one of them is section 36-1-23.1, and it says allows the district attorney to appoint special assistants when the district attorney cannot prosecute the case for ethical reasons or other good cause. That's absolutely crystal clear. Paragraph 14. All the criminal cases refer to the office. Arguably, budgetary constraints may provide good cause for the appointment of special prosecutors. The reason that the district attorney cannot prosecute a case need not be legal or ethical reason. It could be a matter of lack of resources. That's Hollenbeck. Go to Surah. Find it. It says 36-1-23.1, authorizing a district attorney whose office is unable to prosecute a case for ethical reasons or other good cause to appoint a special district attorney. Paragraph 19, section 36-1-23.1, the provision dealing specifically with appointments in, that's not the right one. All right, this one. Paragraph 25, the court indicated, this is a Rosenbaum, Texas case that they're referring to. Under the facts in Rosenbaum, the judge and the disqualified and appointed district attorneys properly followed statutory procedure. And the court indicated that by requesting to be disqualified, the district attorney manifested his intention to give his full power and authority to the special prosecutor in this case. You are manifesting your intention to be disqualified when you use 36-1-23.1, because you cannot ignore the plain language of that statute. You are ignoring the plain language of that statute when you are ignoring how it reads. It's not cannot prosecute for ethical reasons and then cannot or good cause. It's cannot prosecute for ethical reasons or good cause. And by co-counseling, you're prosecuting, and I don't think you disagree with that. I think you're just saying that 36-23-1 allows that. But the other thing is that under this statute, you cannot use it unless you're not going to prosecute. And so you have indicated a dilemma in your response because you're saying that you don't have enough staff to do this. So that would tell me, yes, you cannot prosecute. So you may invoke that. However, you're also saying that I plan to stay in because there's nothing that prevents me from not staying in. And that's not true. 36-1-23.1 prevents you from staying in because you are saying you cannot prosecute. So if you cannot prosecute, you cannot prosecute. I'm curious, there is a footnote in Hollenbeck regarding 36-119. Have you looked at that, Ms. Carmack-Altweiss?
Yes, I have, Your Honor.
And?
Well, I believe, well, I guess what my argument would be is that there's nothing to stop the special prosecutor from then reappointing either me or someone from my office if I were to allow that. But this,
do you think that's a real argument after all is said and done? I will cite case law regarding that.
Well, Your Honor, you asked me about 36-1-19. That I believe applies to people that actually work for the office rather than somebody that's either works for the office of the district attorney or the attorney general. And I don't, the special prosecutor that we have identified would not fit into either of those categories. And so I do not think that that would apply here.
Are you aware of State versus Baca or State versus Lucero?
Yes, Your Honor. I read all of those this weekend.
Okay, and that wasn't somebody in the office?
Well, and in State versus Baca, that person was not appointed as a special prosecutor, that it was a private attorney by the bar, and they said that that absolutely was not allowed.
Do you know why they said that? Because there was no order of the court. I'm not going to, I mean, if you disagree that 36-119 does not allow you to do it, so be it.
Well, then I would ask for leave of the court to look into that a bit further, to see if I can make that work. Otherwise, I do intend to invoke 36-1-23.1.
All right. Mr. Bowles, I am bringing up 36-1-19, although neither one mentioned it, because we are, I'm somewhat cutting to the chase. I see that there's this statute out there, and we are on our way to a preliminary examination. Basically, what I'm ruling, Ms. Carmack-Altweis, is that you either use 36-1-23.1 in the way I've interpreted it, which means that you may not co-counsel, or you stay the course and not use a special prosecutor and prosecute it on your own. I've invited you to look at that statute. You're telling me it doesn't apply. That's fine. Now you're asking me for leave of court. Mr. Bowles, let me hear from you.
Your Honor, and I believe that the cases this court has cited talk about the general specific statutory construction. They mention that, and that the 36-1-23.1 is the appropriate statute when Ms. Carmack-Altweis wants to appoint a special prosecutor. Now, you're right, Judge, there is this other statute, but that hasn't been invoked nor analyzed. And I do, from reading the statute this morning, I do think that that is a different circumstance in what Ms. Carmack-Altweis is trying to do in this particular case. And she's wanting to invoke that statute. So I just don't think she can co-counsel under that statute.
All right. Am I clear on what I've just ruled about 36-1-23.1? It's an either or.
Yes.
All right. If you want to have leave for 36-119, I will allow you to brief it. And I'm doing this. I don't want to appear, Mr. Bowles, like I'm assisting the state. I'm only aware of the statute. I've read it and I've looked at the case law on it, and we're going into May. So I'm sua sponte identifying that statute, even though the state did not identify it as authority to do so. I'm curious. So when I say that the briefs have to be done by Friday, I mean Friday, like before Friday. So brief it, and I want them close of business Thursday, and then Friday. Well, I'll have to figure out when we can set this, but it will be a quick turnaround. Okay, I'll either set it Friday once I look at my. Are you both available Friday?
Yes, Your Honor.
Yes, Your Honor.
All right, and if you don't want to do it, Ms. Carmack-Altweis, then just say you don't want to do it, and you're not going to. And then if Mr. Bowles and Ms. LeBlanc or other counsel for Mr. Baldwin can agree, then that you can pursue this, then you can submit an order as required under 36-1-19. Any questions on what I'm ruling?
No, Your Honor.
Okay, Mr. Bowles, will you please prepare the order?
Yes.
Regarding 36-1-23.1?
Yes, Your Honor.
All right. Thank you for your appearances today.
Thank you,
We're
Your
in
Honor.
recess.
Thank you, Your Honor.
Your Honor, have a good